This is about that review of your estate planning program that you go through before you make it official. So, done this for so long, have dealt with so many thousands of people. I know that everyone is in a range somewhere. Some people are on one side saying, "Paul, I trust you. I know what we talked about. Show me where to sign." And then other people are, Paul, I'd like to know, on the other end of the spectrum. Paul, I'd like to know what every word means. What does this mean? What does that mean? What does Pact De Non Alienando mean? And so, but most people fall somewhere in the middle. So this is my suggestion as you review things, and before you make it official, what kinds of things should you be looking at? Man, close. So really, it's all of the customized, relevant provisions in estate planning documents. Just like when you buy a house or get a mortgage, there's a lot of paperwork and there's a lot of just standard stuff. But it's really the customized stuff that you want to look at. So things like, we'll start with in your power of attorney. Is it durable or is it springing? Does it spring into effect when you become disabled? Who did you designate as what in Louisiana is called your agent? Did you designate one person or two? Did you designate a backup? If you designated more than one, how do they have to work together? So those are some of those customized provisions. In your living will, that statement about life support machines, at least in Louisiana, there's in the kind of standard version, there's a place to initial regarding nutrition and hydration and whether you'd want that authorized or removed. If you're in that vegetative state, no chance of recovery, so your family knows what you want. And then in your will or trust, it's want to review the provisions of who you left things to and how did you leave it to them. Did you leave it to them what we call outright, where they can have it kind of in their lap, and that's okay for some people? Or did you leave it so that it would remain in trust so that they would get it over time? A lot of people do that when they leave things to younger or just kind of less financially mature people. Want to make sure they benefit from it over their lifetime. And then some of the who's going to be in charge, who's going to be the trustee of your trust or the executor of your will. Again, one person, two backups, all that stuff. Don't get too caught up in some of the stuff that quite frankly is in all those documents, and sure, you might want to know what it means, and you can kind of look it up, the information on anything on the internet these days. But I would not get real hung up on some of the standard stuff that's just in all the documents, because you'll be losing focus on the things that are most important. So that's just everybody's different. Everybody's circumstances are unique. But what we like to focus on are those really substantive provisions, those things that mean the most to you, those things that will affect you and your survivors that you leave behind. And then once you feel comfortable that it's the way you want it and the way you need it, then boom, go ahead and make it official. Get everything in place, get it organized, and then have that peace of mind knowing that you've got things in order. Important process, so let's get to it.